NCADV. We're just going to give folks 1 minute to log in and we'll get started here shortly. So while you're waiting for the presentation to start, please share in the chat box where you're from and what the weather might be like today. Abigail, thank you. It's good to hear from everyone. Oh, it's raining in Boise, Idaho. Sorry to hear that. All right, it looks like we've got about 40 people online. Wonderful. Thank you for sharing, everyone. Again, my name is Gretchen Shaw. I'm the Deputy Director here at the National Coalition Against Domestic Violence, and I'm going to move through just a few housekeeping slides and some polls that will allow us to get to know you just a little bit better. So today's presentation is Domestic Violence and Firearms, Restrictions, Relief, Reports, and Resources. And we have wonderful presenters today. Rachel Graber with NCADV, Lisa Geller with the Educational Fund to Stop Gun Violence, and then both David Keck and Alicia Nichols with the Battered Women's Justice Project. So thank you all so much for being with us. All right. I have no doubt that everyone on this webinar is probably more familiar with Zoom than they would want to be at this point, but just for the intents and purposes of today's webinar, we're going to be fielding questions, waiting until the very end to answer most questions. But if you have one, please enter it in either the chat box or the Q&A box. I'll be watching both of those closely, and we'll make sure that, time allowing, that we'll answer as many questions as possible. So before we begin, the questions that we get most frequently are we going to receive a recording of this and a copy of the PowerPoints? And the answer is yes to all. So we are recording this session and we will be sharing that recording with all registrants. We'll also include a link to a downloadable version of the PowerPoint, a link to a downloadable certificate of attendance. And then we also have a short survey that we would really appreciate it if you all would fill out. That's helpful to us for our records, for all sorts of information, as you all probably can guess. So also, those of you who are members with NCADV are familiar with our member webinar advocacy series. Our next webinar is going to be held on June 24th. It's entitled Immigration Policy Updates Impacting Survivors in the Midst of Constant Change. And it's being presented by Grace Wang from the Asian Pacific Institute on Gender-Based Violence. So of course, if you're a member of NCADV, you can attend all of our webinars included in your membership and then access, I think we have over 40 webinar recordings in our member library, which provides a wealth of information for you all. If you're non-members, the access for a one-time access for webinars is $75. So for those of you who are tweeters, I'm not, please make sure that you're following or using the hashtag #AdvoChat today. If you want to tweet along with today's webinar, you can also follow us at NCADV. So, all right, we're going to do just a few polls, quick polls to see who we've got on today's webinar. So if you could just let us know how you would define your community type as either urban, suburban, or rural. We'd love to know. Great, so we've got a lot of rural attendees today. It's really interesting. That's awesome, fabulous. Okay, so we'll share the results. Most folks identify as a rural part or in a rural area, followed by urban and then suburban. Okay, I've got one more poll. We're curious to know who's participating today, how you would define your role if you want to, you can also always answer other and then share that other category in the chat box if you would wish to do so. Yep, the majority of folks identify as domestic or sexual assault advocates, which is pretty typical for our webinars. Followed by other, and then some identify as a survivor of domestic or sexual assault. So I'll share those results. All right, great. Thank you all for that. Okay. As soon as I figure out my keyword here, oops, I'm gonna go ahead and quickly introduce today's panelists and read just a few sentences about each. I would encourage you to visit NCDV's website for more information about each of today's presenters. So we have Alicia Nichols, who is the Director of Innovation at the Battered Women's Justice Project. She also serves as the Deputy Director of the National Resource Center on Domestic Violence and Firearms, which is a project of the Battered Women's Justice Project. In addition to many things, she's led the restorative justice program at the Minnesota Department of Corrections and advocated for victims of violence at the Office of Justice Programs in the Minnesota Department of Public Safety, Minnesota Coalition Against Sexual Assault, and Minnesota Coalition for Battered Women, and the Central Minnesota Sexual Assault Center. So you worked a lot of places and very, very knowledgeable about this issue and others. We also have David Keck today, who is the project director of the Battered Women's Justice Project National Center on Domestic Violence and Firearms since its inception in January 2017. Prior to joining BWJP, David served as a court commissioner for Winnebago County, Wisconsin for 10 years. During this time, he helped develop a protocol for firearm surrender in domestic violence civil protection order cases, which became the framework for Wisconsin's SAFE Act, passed in 2014. In 2008, David also co-founded the Winnebago Free Legal Assistance Clinic and has been the director ever since. So thank you both for being with us today. Also, we have Lisa Geller, who is the State Affairs Manager at the Educational Fund to Stop Gun Violence and the Coalition to Stop Gun Violence in Washington, D.C. Lisa's work focuses on research advocacy and implementation of evidence-based gun violence prevention policy. Lisa also helps manage disarmdv.org, which is a comprehensive and interactive website that compares laws between states, presents statistics about domestic violence and firearms, and provides information on the statutory process of firearm removal in cases of domestic violence protection orders. And of course, we also have today our wonderful Rachel Graber, who is the Director of Public Policy with the National Coalition Against Domestic Violence. So Rachel has both organized and participated in numerous congressional briefings about domestic violence, and she has been instrumental in the development and passage of important legislation to protect survivors, to provide services, and to keep firearms out of the hands of abusers. She is co-chair of the National Task Force to End Sexual and Domestic Violence's Firearms Subcommittee, the co-chair of the NTF's Outreach Committee, and is an active participant in many other areas of domestic violence related and intersectional public policy. She was also one of the primary creative forces behind Disarm Domestic Violence, which is a project of many of us, NCDV, the Coalition to Stop Gun Violence, the Alliance for Gun Responsibility, and Prosecutors Against Gun Violence. So thank you all so much for being with us today and for presenting this incredible webinar. I will now turn it over to David. I think you're the first who's going to be speaking.
Yes, thank you.
Okay, wonderful. I'm going to turn off my camera and mute myself, but I will be here throughout the whole session. So I'll be monitoring the chat box as well as the Q&A, and I will pop in when it's appropriate.
Thanks. So if you could take us to the next slide.
Be happy to. There you go.
Oh, I think we need to one
back.
No, the next one up. Thank you. So what I'm going to do here really quickly is actually read. I don't usually read from slides, but I'm going to read this to you because our agenda here is a little bit different than some webinars what we'd like to do and what we've got planned for today is kind of an ambitious agenda. We're going to be covering a lot of topics. Domestic violence and firearms is kind of a narrow intersection, but there's a lot of information about it. It's actually a very complicated area. And so what we'd like to do today is sort of expose everyone to a lot of different topics that are subtopics here. And then you heard about a poll at the end. We'd like to find out from all of you what areas you would like us to take deeper dive and deeper coverage of in the future. So I'm going to start out with some background, some statistics, a little bit about domestic violence and firearms. We're going to then cover mass shootings and suicide, talk about the federal law regarding firearms and domestic violence, state laws and how the state laws and federal laws interact with each other, prohibitors under both state and federal law, and then relinquishment, which is a big topic, at least from, kind of in our office, which is taking firearms away from domestic abusers. We've got domestic violence protection orders versus extreme risk protection orders. And we want to spend a few minutes talking to you about kind of the difference, the historical difference and the practical difference, and how the two types of orders interact with each other. We're then going to go into safety planning around survivors of domestic violence where there's a firearm present. We'll talk then about relief in domestic violence protection orders, a little bit more there about relinquishment and how that can take place. We'd like to spend some time also on gaps in state laws, and also gaps in federal law, and also the gaps that occur because of the intersection of state and federal laws. Federal legislation is going to be one of our last topics to talk about, and including some of the very important legislation that may be becoming reality here in the near future. And then we've got resources. We've heard about the poll. We'd like you to take the poll so that we can learn more. Questions, we'd ask that you hold your questions until you can certainly chat those as they come up, but we'll probably address the questions at the very end. So if we could have the next slide, please. This is an acknowledgement that we have to put up. So Alicia and I are with Battered Women's Justice Project, which is funded by the Department of Health and Human Services. And we have to put a disclaimer up there, just acknowledging that is who has supported this presentation, at least from our part. So the next slide, please, and then we can get into some substantive information here. Firearms disproportionately impact women. I don't think there's any doubt about that. More than 1 million women here alive in this country report of either being shot or being shot at by an intimate partner. Many more of those, over 4 million, report that they've been intimidated by a partner with a gun. This intimidation, as most of you probably already have experienced, doesn't necessarily rise to the level every time of someone pointing a loaded gun. It can be something like we've probably all heard, where there's an argument and the guy with the gun gets his gun out and starts, sits down at the kitchen table and starts cleaning the gun. It's a not very subtle threat. It's a very clear threat, but it's a commonly used one. I've had clients who have come home and discovered that there's a receipt for a gun that they didn't realize was going to be purchased. So a lot of people report and experience the intimidation and coercion of having a firearm in the home that are not threatened in a traditional way that we might think of. So this is something that's very real, and it's very prevalent. And with the increase in firearm sales that we've seen over the last year and a half, I think it's something that we will unfortunately be seeing more of. More than 600 women in this country are shot to death by intimate partners. And it's important also to note here that this is intimate partners are, generally, it's generally a male partner. It's generally speaking a husband, ex-husband, boyfriend, ex-boyfriend. These, I think, are the individuals who are most likely to commit a homicide against a woman is a male intimate partner. Over half of these homicides are committed by firearms. And I think close to, well, again, over half of those are committed with handguns. This is a phenomenon that's really reached a level of concern, around the country. It's an epidemic, to put it lightly. Could we have the next slide, please? I think this is Lisa.
Yes.
Okay.
Thank you. So now we're going to shift. We have this background in the context of this conversation. And what I want to talk about next is this intersection between domestic violence and mass shootings and suicide. And what I'm going to talk about specifically is a new study that was published last week in the Journal of Injury Epidemiology that I authored with 2 researchers at the Johns Hopkins School of Public Health. We know that mass shootings are very rare events, but they do capture the media attention, and there's still not a lot known about why they occur. And so we wanted to focus specifically on the role of domestic violence in these incidences. A lot of focus is on these public mass shootings. They usually have more people that are shot, more people that are killed. But looking just at these public events disregards a lot of the DV incidents that are mass shootings, and those tend to occur not exclusively, but in homes or in what we would think of as private settings, and often aren't part of this media narrative of mass shootings. So what we did was we looked at 110 mass shootings defined as 4 or more shot and killed, not including the perpetrator, from 2014 to 2019. And we looked specifically at the perpetrator's history of domestic violence, looking at news reports, also looking at who the victims of these shootings were. And we found 2 main findings, and then I'll talk about another finding related to suicide. What we found specifically was that when looking at what percent of mass shootings are DV related, was that if you count shootings where the victims were family or intimate partners, almost 60% of these mass shootings were related to domestic violence. And if you expand to include these shootings where the perpetrator had a history of domestic violence, but did not necessarily shoot family or intimate partners, that number jumps up to 68.2%. So almost 70% of all mass shootings in this study period had a relationship to domestic violence, whether through the perpetrator's history or through directly the victims that were shot or killed. The second main finding of this paper relates to case fatality rates, which are the proportion of firearm deaths compared to the total number of people shot. And what we found there was that there was a significant increase in the case fatality rate when we look at these domestic violence shootings, meaning that you are more likely to be shot and killed and not survive those wounds if it's a DV related shooting. And one of our theories for why this could be is that these are more targeted shootings. They happen, like I mentioned, in sometimes private spaces where it's not as easy to escape. If we're comparing it to a shooting like the Las Vegas shooting, where this was a large open area, of course, a ton of people were shot. This was actually excluded from our study because it was a clear outlier, but that's an example of a shooting in a public space where it may be less targeted. You're not necessarily going after one individual person, but more going after a whole group of people. Specifically related to suicide here, what we found was that 55 perpetrators of 53 mass shootings during this study period died. The majority of them, almost 71% of them, died by firearm suicide. And when we look at who died by firearm suicide, 36 of the 39 perpetrators who died by firearm suicide were perpetrators of these DV-related mass shootings. And then if we specifically look at the number of DV perpetrators, there were 65 DV-related mass shootings, and 65% of those perpetrators died during the shooting, and the majority of them died by firearm suicide. So there is this relationship between domestic violence and mass shootings, Then there's also this relationship between perpetrating a domestic violence related mass shooting and dying by firearm suicide, taking your own life at the end of this act. And sometimes these acts are not even intended necessarily to be these mass murders, but it's really a perpetrator who has suicidal ideation, and in the process of taking usually his, but sometimes her own life, he also takes the lives of everyone in the home. And so when we're talking about how to prevent mass shootings, we want to also focus on how to prevent suicide and how to prevent firearm suicide, because there is this link there. Next slide, please.
Do you want me to take this one? Okay, we're looking at the federal law, 18 U.S.C. 922, subsection G 8 and 9. And these are the two provisions of the 9 provisions under federal law which prohibit purchase or possession of firearms. These are the two which are directly related to domestic violence. The first is subsection 8, which prohibits purchase or possession of firearms to anyone who is a subject of a protection order, what they call here a qualifying protection order. And I'll explain qualifying here in just a second. The distinction between that and sub 9, which is the conviction for a misdemeanor crime of domestic violence, there's really two important distinctions. The first one is under subsection 8 for a protection order, the prohibition under the federal law is in place while the protection order is in place. When the protection order expires, the prohibition expires. It's not to say necessarily that that individual always gets their firearm returned, but at least this order no longer prevents that from happening. Under subsection 9, that's the conviction for a misdemeanor crime of domestic violence. That doesn't have a time limit, either going back into the past of when the conviction was or going forward for how long the prohibition's in place. It's essentially a lifetime prohibition unless the state where the conviction occurred provides for some kind of relief, restoration of civil rights or something similar to that. The other important distinction between subsection 8 and subsection 9 is those individuals who have that misdemeanor crime of domestic violence, there is not an exception for military or for law enforcement. And this is something that I think that comes up frequently around the country, the kind of the distinction there, and it's important to remember that the misdemeanor crime of domestic violence does not have that exception. It's best when you're looking at these to look at specifically the state you're living in. The important thing about the way this interacts is there are no federal protection orders. Those are done at the state level, and these misdemeanor crimes of domestic violence are the same thing. So the important question to look at when you're looking at either of these, if you've got someone who's been convicted or is subject to a protection order in your state, pursuant to that state law, it's important to look at how the elements of your state's definition of those matches with the federal definition. And this is something that can be very complicated. It's something we could take a deeper look at sometime in the future. If you've ever got questions about it, please consult one of us. We'd be happy to walk through that and help you with that. But that's federal prohibition sort of in a nutshell. Could we have the next slide?
Great. So now we're going to do a brief overview of state law, very brief. Dave gave the outline of why we need federal law, but we also want to talk about why we need state law and where state law plays into this conversation. So federal law sets this floor for kind of the bare minimum of laws related to firearms and domestic violence, but state laws can offer another layer of protections and often are included to make stronger protections here as related to domestic violence and firearms. This state law does not require an interstate element. It's focusing on, the laws in one state, Maryland, Virginia, whatever state you're looking at. And state law enforcement and prosecutors enforce state law, and addressing armed abusers is and should be a great priority here. In addition, the federal government does not issue civil protective orders, domestic violence protection orders. We're going to talk about those in more detail later. It's the same thing with extreme risk laws. Those are issued in the states. That's not federal law, but every state does have some form of a civil domestic violence protection order. However, they vary greatly by state. Specifically, when we're looking at the firearms provisions, there are some states I will talk about one in a second that offer greater protections. There are some that, you know, have no protections related really to firearms or don't have clear enforcement, relinquishment, removal processes in place. So that's kind of where state law plays in. There's also the aspect of full faith and credit, which means that a protective order that's issued in one state is valid in every other state. Those protections will carry over, which is very important because we know how easy it is to travel within the United States, and we know how critical it is to make sure that someone who is subject to a protective order in one state cannot just flee and kind of get rid of their responsibilities under some state's protection order. I will kick it off maybe to Dave or Alicia to give a little bit more about full faith and credit before I talk a little more about state law.
Thank you. I was just going to just look a little bit at what it means, what it does not do. I think some of the issues, and I think Lisa's kind of touched on these already. There are states that have, for example, that have a mandatory relinquishment provision in a protection order that may not be recognized by the other state. I can tell you that when we were first rolling out and first putting together our protocol, we had an evidence technician in our county who was very much in support of this. And I know there were occasions when she would get on the phone with the other sheriff's department in another state and urge them to follow our state's order to take firearms. And so she wasn't always successful, but at certain times she was able to do that. I don't think it's something that's required, but I think it's something that can take place. The other thing to look at, I think, with these is actual service of the order in the other state. I think in most states the requirement is personal service, and I think that's going to be dependent on what the issuing state's law is. But this can also be, like I said, this could also be a complicated issue. If you're having questions about this, or if you want to look at it more carefully, you can also either call us or contact us, or we can put you in touch with our office that specializes in protection orders and full faith and credit.
And Dave and Lisa and Rachel, I'm going to go ahead and drop that information for the organization that Dave just mentioned into the chat for all of the participants.
Thank you. And next slide, I think.
Yes, thank you. So here we have a comparison. This is a resource that we're going to talk about quickly at the end, but it was mentioned in our introductions, which is disarmdomesticviolence.org or disarmdv.org. And this is a website that was a partnership of a number of organizations. It's a really great resource to compare state laws related to domestic violence and firearms. So one of the comparisons I put up here was comparing California and Texas. As you can see, the shaded in bubbles are indicating what provisions or protections are included in those laws. And in general, if there are more shaded in little bubbles, that means that the laws are stronger. There's more protections, surrounding dating partners, not just spouses, surrounding removal processes. But as we mentioned, state laws vary significantly. Some are weaker than federal law, some are significantly stronger. California is listed up here to show you what those provisions are there, but you can also look at the website and find out a lot more information. State laws are being updated constantly. One of the bills in the California General Assembly now is Senate Bill 320, which is in the California Senate currently, to strengthen the existing domestic violence protection order process. So even though California has a number of protections and is considered generally a good law, especially compared to some other states, there's still always room for improvement there, and especially as it relates to firearms, which we know are the most lethal means of committing violence and must be removed when someone is at risk of harm. And so this bill clarifies the relinquishment process. So even though they had a process kind of in place with their law, it's somewhat ambiguous. It clarifies when firearms need to be removed, where they go, how they are being removed, and just some of those things to help law enforcement and the people actually removing firearms know how to do it, where to do it, and when to do it. So next slide, please.
Hi, I apologize in advance for any cicada sounds. I know everybody's talking about the cicadas. I was told the other day that if you have a shrimp allergy, you should not eat cicadas. So if you don't take anything else away from this webinar, remember, don't eat cicadas if you have a shrimp allergy. So I'm going to talk a little bit about federal jurisdiction. So as Lisa noted, state and federal laws are complementary, and both are really necessary to protect survivors. Federal law provides that floor, which ensures that there are minimum consistent protections nationwide, even if an individual lives in a state with a weak law. So the federal government is responsible for enforcing federal law, as you might imagine. That means that the FBI and the ATF investigate potential violations of federal firearms laws. And then the US attorneys are responsible for prosecuting offenders. The federal government does not enforce state law, and states do not enforce federal law. So it's, and as Lisa mentioned, enforcing intimate partner firearm prohibitors is more of a priority for the states than for the federal government. In cases in which the federal government does decide to intervene, they do have substantial resources with which to investigate, to seize firearms, and to prosecute. So you'll see also there's the requirement for an interstate nexus. You know, there's a commerce clause and whatnot that basically has been interpreted to allow the federal government to govern the firearm access, just because firearms are transported, sold interstate, made of parts that are manufactured interstate, from materials that are mined interstate, etc. Next slide, please. So just as the federal government has jurisdiction over violations of federal law, like I mentioned, states have jurisdiction over crimes committed in their states under the laws of their states. So they can't prosecute violations of federal law. They can't prosecute crimes committed in other states, and they can't prosecute crimes committed in their state that violate the laws of other states, but not their own, right? In cases in which a person violates both federal and state law by possessing a firearm, those laws can be enforced by both the state and the federal government, but those cases would be prosecuted separately, tried separately in separate courts with different prosecutors. You know, there are some states, there are some circumstances in which a state might ask the federal government to intervene under federal law. So for example, when you have an abuser who is stockpiling firearms, you have a small state that might not have the resources to put, I don't know, lay siege to a shack in the woods and take 700 firearms. Or, also in a situation where maybe a state doesn't prohibit abusers from possessing firearms. So only the federal law applies. And so they have to call on the federal government to prosecute those crimes. Again, as Lisa mentioned, many states have laws that are stronger than federal law, such as laws that prohibit adjudicated dating partners from possessing firearms. We call that the dating partner loophole or the boyfriend loophole. As a practicality, state laws can also be substantially more prescriptive than federal law. So for example, federal law prohibits certain adjudicated abusers from possessing firearms, as Dave mentioned. But federal law doesn't contain any provisions as to how an adjudicated abuser has to dispossess themselves of their firearms, right? Whereas, again, as Lisa mentioned, a number of states do have statutory processes by which a prohibited abuser will relinquish their firearms, by which they prove to a court that the firearms have been relinquished, and then also by which the individual can retrieve their firearms at such time as they are no longer prohibited from possessing them. State laws also govern law enforcement's responsibilities and options when responding to a situation in which an abusive partner possesses firearms. So for example, law enforcement is responding to a call, there's a firearm present, State law governs whether they can take the firearms, whether they can hold the firearms, what that process looks like. And then state laws also govern courts' issuance of protective orders and the relief available to survivors. So for example, some states automatically prohibit respondents to protective orders from possessing firearms. And in these states, if you actually look at the order, it's often like written in there as relief and it automatically has a check mark next to it. Some states also automatically require respondents to relinquish their firearms. Many states prohibit respondents from possessing firearms, but don't actually have any relinquishment requirements in state law. And then with one potentially notable exception, which is South Carolina. And the last time I talked to the folks down in South Carolina, they still hadn't figured out how to implement their protection order laws. But with that South Carolina side, states that don't automatically prohibit respondents from possessing firearms or explicitly authorize courts to prohibit respondents from possessing firearms, they can order whatever relief they deem necessary to protect the survivor, including prohibiting the respondent from possessing firearms. So either it's required, judges are authorized to prohibit firearm possession, or there's a catch-all, that's whatever relief necessary. Next slide, please. So while several states do require respondents to protective orders and people convicted of domestic violence to relinquish their firearms, and judges can also write in a requirement into protective orders in other states for relinquishment, there does need to be an enforcement mechanism, right? So even in states that have a robust process written into the law, Lisa mentioned California has a process. Many jurisdictions don't have the infrastructure that they need to enforce the relinquishment requirements. So, a lot of us who are here on this webinar today have actually done some of this work with local jurisdictions to develop policies and protocols for the surrender, storage of firearms, and then also the return of firearms when an adjudicated abuser is no longer prohibited from possessing firearms. These policies and protocols can be used both in the case of civil protective orders like we talked about, or criminal protective orders for that matter, but in the case of convictions. So ideally, a comprehensive policy will include a multi-level collaboration, so involve state, county, local prosecutors, and law enforcement and judges. So they all have a role to play in ensuring survivor safety. Some of those will overlap, so it is important for folks to know kind of what their roles are in this process. They should be developed in conjunction with stakeholder groups that will be impacted by the policies. So that includes, but isn't necessarily limited to domestic violence programs, survivors, culturally specific organizations, family law attorneys, and defense attorneys, as well as, obviously the law enforcement and prosecutors and judges. Each stakeholder does have a unique perspective that is necessary to ensure survivor safety, safety of other parties, and then also abuser compliance. So policies and protocols, they should include a number of different components, which include, but again, are not necessarily limited to the process by which it is determined that a prohibited person has a firearm, how many firearms they have, etc. The process by which firearms are relinquished, if applicable, and to whom, if it is not explicitly spelled out in state law. The process by which the individual shows the court that they either have relinquished their firearms in accordance with the protocol or that they did not possess firearms in the first place. The parties responsible for receiving and storing firearms. The process by which individuals have their firearms returned upon the expiration of a protective order, which would include a determination as to whether the person is prohibited from having firearms for a different reason. Safety planning with the survivor throughout the process. And I know this is a favorite one of Dave's, protection from self-incrimination. If an individual tells a court they're in possession of a firearm before the relinquishment process, maybe they're prohibited from having the firearm in the first place. And if they tell the judge, then that could potentially be self-incriminatory. And then also, when the transfer of firearms takes place, also need to have protection from self-incrimination, because by transferring the firearms to another individual, you are it's saying that you have firearms. So next slide, please.
Great. So Dave, do you want to start or should I?
If you want to start this one, I'll do the next one.
Okay, perfect.
Okay.
We're going to talk about a few policy options that exist. And I want to just state from the outset that it really should be left up to the victim, survivor, and anyone that they are confiding in to come up with a plan for removing firearms or for getting, being separated from an abuser. So these are just some options that exist. I'm not necessarily saying that these are always going to be the best tool, but I do think it's important to talk about domestic violence protection orders and extreme risk protection orders. And so I'll start with extreme risk laws. These are also civil restraining orders that are modeled off of domestic violence restraining orders. The focus for extreme risk laws, and I should backtrack a little, these came out, the first modern day extreme risk law was passed in 2014 in California. And since then, 19 states and the District of Columbia have these laws on the books. And they are just designed solely to remove a firearm. They do not offer any other protections. It's simply a firearm removal process. It can be used in cases of domestic violence, but it can also be used for preventing suicide, which is how it is most often used. It can be to prevent incidences of mass violence, which it has been used for, especially in California. And so these are civil orders that temporarily prohibit individuals at risk of violence, either towards themselves or others, from purchasing and possessing firearms. And actually, this is outdated. I realize it says 17, it should say 19 states in DC. So that is the crux of the extremist law. If you take nothing else away, it is just a firearm removal. It is a temporary law. There's an ex parte component, and then there is a full order, which varies, but typically lasts, up to 1 year. And after that period of time, risk can be reassessed. And if it is determined that there is no longer a threat of violence, again, towards self or others, then the firearm can be removed. So this is not a permanent ban on firearm ownership. Domestic violence protection orders, on the other hand, give survivors of domestic violence a mechanism to prevent themselves from abuse. And there are multiple types of provisions and protections offered through a domestic violence protection order, which can include a firearm provision, but can also include no contact orders, stay away provisions, move out provisions, provisions related to counseling. And then finally, as noted here, it can also include firearms, but the extreme risk law is just about removing firearms. Next slide, please.
Okay, thank you. So as Lisa's pointed out here, there can be two options for survivors of domestic violence with regard to firearms. It's important to note the distinction here that the domestic violence protection order that has a prohibition on firearms, the prohibition on firearms, and in some states, the order to relinquish those firearms, those are consequences of the protection order. The extreme risk order is focused on the removal of the firearms. And it's important to make that distinction because there isn't a separate inquiry in most cases. Some states have something of a separate inquiry about whether or not to remove the firearms. But the petitioner, a survivor who comes to the court asking for a protection order from a domestic abuser, is asking for that protection. It might include no contact. It might include stay away. Physically stay away from my home and my place of employment. And it carries the additional consequence of the prohibition on the firearms. And this is because Congress did this a number of years ago because of the statistics and studies that showed the connection between domestic abusers and their propensity to commit violence. That's why they're prohibited from having firearms. The extreme risk order focuses only on the firearm. And that's an important distinction. It doesn't provide any other protections or prohibitions other than taking the firearm away. Sometimes we hear questions about, and an individual? Could somebody file both? They're not inconsistent with each other, but I think from my perspective, I would question why someone would really need to do that. If you're in a jurisdiction where you're being your clients are being urged to do that, please let us know, because I have concerns about courts in some areas starting to conflate the two standards and sort of confusing those and setting up survivors into a situation where they're really being asked to prove something to a much higher level than they ordinarily would have to do that. So it's important to recall that there's a distinction and the reason for those distinctions. Next slide.
So this slide is just a little bit of a summary of the petitioners for both of the orders and the protections that are offered. So the petitioners for domestic violence protective orders are just family and household members. So law enforcement therefore cannot file or petition for a domestic violence protection order, but they can, and they are allowed to for every state that has an extreme risk law. There are also additional petitioners for extreme risk laws in some states, but law enforcement is a eligible petitioner in every single state. So there are obviously potential benefits, but also potential drawbacks with having law enforcement intervene. I have heard from some victim survivors and advocates that it can be good to have law enforcement because it can be somewhat of a neutral party that is petitioning for this firearm removal and maybe doesn't put as much onus on a victim themselves if someone is known to law enforcement. But of course, there is always going to be complications when law enforcement are involved in this. And so it's just really important to consider both aspects of this. The extreme risk law was built to be a preventative tool. This is not intended to be used after something has already happened, because then it's typically in the criminal system. But the extreme risk law is really intended to be used when someone is known to be at risk of harm. And what we really want to do is put time and space between them and a firearm, especially when we're talking about suicide prevention. We know that when a firearm is used in a suicide attempt, it's almost always lethal. And so if we just put this time and space between an individual and the suicidal ideation and remove a firearm, they're much more likely to just not only survive, but also not attempt again. Okay. Rachel, did you have something to add on the protections?
Oh gosh, I didn't realize I wasn't muted this whole time.
Oh, okay.
I do have one thing to add though, and I think this just kind of underscores what Dave was saying. You know, it's rare in domestic violence situations that an IRPA would be a better tool than a DVPO. In almost every DV situation, we would definitely encourage that to be the first option. The other thing I did want to mention is going back to that question of full faith and credit. Unless a state has explicitly entered into a reciprocity agreement with the issuing state, there is no full faith and credit for IRPOs. So maybe they're prohibited from possessing a firearm in California, but then they go to Montana and they can buy a firearm there. There isn't a federal, full faith and credit, a federal law, or any requirement for states to protect IRPOs from other states. So I did just want to add that.
That is very important. And there are some states that have made that kind of explicit. But again, when you're talking about a law that doesn't exist in every single state, there are obviously significant gaps, like Rachel said, to just drive over to another state and be able to buy a gun if you're just prohibited under the extreme risk law. Next slide, please.
All right, I'm so sorry, everyone. I have a 10-year-old who is home with me who has decided right now he wants my attention and to talk to me. So I am so sorry. I have a question. I am so sorry, everyone. I know you all have kids at home too. And he's sick, so on top of that, I apologize. So I am here today to talk with all of you about safety planning around guns with victims and survivors. So the first area where I want to start is really around the disclosure of risks, and then we'll talk about autonomy. And so my colleagues have, I think, teed it up very nicely for me, where you, right, if you have not already experienced this with the survivors that you work with, we know that there is an increased lethality for survivors when guns are present in the home. There are factors that we have to make sure that we are clearly articulating and talking with survivors about, so that they can make the best decision possible. For some survivors that Dave and I have spoken with, the removal of their belief is that the removal of the firearm could actually be more lethal or increase the chances that they would be killed. And so talking through the risks of firearms with survivors so they can make the best decisions possible in that moment is critical. So some of the factors associated with lethal gun violence that I wanted just to talk about. Right, so when you're talking to survivors, and this goes into the considerations as well as the what do you need to know, what does the survivor need to know, how it is that you can determine if the survivor in fact has options, and what are considerations that you have in discussing those options. So some of the factors that we should be taking into consideration are around recent acts or threats of violence against self or others from the perpetrator, patterns or acts of threats of violence within a certain period of time. It tends to be 12 months. If there's been a violation of a protection order or a conviction for a domestic violence offense. Certainly, as Dave mentioned earlier, the acquisition or the purchasing of a firearm when the abuser hasn't previously owned one certainly is something that we need to pay attention to. History or use or attempted use of course, a threat of physical force. And again, as Dave had mentioned earlier, just the reckless use or the brandishing of the gun, or right, taking the gun out to clean it during an argument, or I've heard situations in which ammunition has been brought out, and names of children and family pets and things have been written on that ammunition. And so talking about how the threat of firearm violence is presenting in the relationship is extremely important. One of the other things that are indicators, of course, of lethality is a history of stalking and certainly strangulation. So we know that there's a significant impact. I was going to talk a little bit about the potential for suicides and the risk to the family and community. I think my colleagues have, and Lisa has really set that up really nicely for all of you. But going into then next around autonomy and working with survivors, you know, we victims and survivors cannot and should not be looked upon as, you know, canaries in a coal mine. And what I mean by that is that, yes, there is an emphasis on community and family safety that should be taken in consideration. But that can be almost an impossible position for the survivor to be in, where they're feeling as though they are choosing between personal safety and community safety, and it can be an unfair burden. It also continues to place the responsibility on the victim and the survivor and shifting it there, and not really taking into consideration the actions and behavior of those who are causing harm and those who are abusing. And something that Dave will talk about I think in the next slide when we're talking about relief through protection orders is how it is that you even obtain information about the presence of a gun. And is it in the home? Do they have access versus ownership and possession? And so not relying on the survivor to be the best source of information on where those firearms are, and which speaks to, of course, confidentiality. If a victim is going to share information through the legal system or with an advocate about the use and threat of firearm violence, again, we know that it can increase the lethality and risk of danger for that survivor. And so we need to be careful about how it is that we solicit the information, who we share the information with, and how it is documented. A second piece of that is notification around if a firearm is going to be, let's say a firearm has been removed and at some point is then going to be returned. We need to have proper victim notification in place so that survivor knows that that is happening. Dave and I have worked with a survivor in the Midwest who was not aware. She actually requested an order that did not remove the firearm because she felt like it would cause her more danger potentially. And so she had not requested that, was not looking for that, and then was one day looking at in the state system at her divorce decree and learned that her abuser, her ex-husband, had in fact been picked up by the ATF on a federal firearms violation, to which she had not received notification, and it put her in a great sense of danger, that she had been the one who had turned him in, which was not the case. So notification is another important piece. Can I have the next slide, please? So again, questions to be asking survivors: what threats have taken place? And to, understanding and articulating what threats have taken place can be extremely helpful for advocates when they're assisting survivors in completing paperwork and sharing what information they can in a protection order about why it is that they are seeking relief and why they're asking that that firearm be removed, even if that firearm hasn't been pointed directly at them or hasn't been fired at them. Just right, knowing, Dave, your story of a survivor coming home and finding a receipt for a handgun on the table would be enough, certainly, to make me extremely nervous about what could potentially happen. Asking what the survivor is most concerned about regarding the abuser's use of firearms. What do they need to know? What type and how many? I had given a little plug for our sister organization, the National Center on Protection Orders, Full Faith and Credit, in the chat earlier. They have developed really excellent tools and checklists for advocates to use with survivors, to talk with survivors about how many guns are present, identifying, what is the difference between a handgun and a rifle, or what it, like, I am not a hunter. I don't know anything about the different types of guns until I started doing this work. And that can be really helpful if in fact the survivor is looking to have those removed, to know where they are and what type. Again, other related information like the ammunition should certainly be addressed. If I can go to the next slide. And Dave, this is where I would like you to jump in. And if you can, when we talk about accessing relief through the system.
Thank you. I can do this really quickly. I'm not sure how much time we have left, but this is these 4 questions. I'm going to go through them very quickly, but I'm going to indirectly answer. We had one chat, an individual asking about an incident in Mississippi and in Alabama, and I'm going to try to answer your question by pointing this out. This is something I think we all should be doing, is asking ourselves these 4 questions. If you hear about somebody in court or see somebody in court, ask yourself, first of all, does this proceeding mean that this individual can no longer possess a gun? The answer is yes. Then you go to the next question. Does this individual possess guns? And is that question being asked in the courtroom? Next, if that's the case, has the court ordered this defendant to relinquish those guns? And finally, how do we know that's taken place? These 2 incidents that were sent in the chat from Mississippi and Alabama are prime examples of exactly what we're talking about here, which is the honor system. Presumably, in the Mississippi case where the protection order was put in place, presumably the court read to that defendant the federal prohibition on possession and purchase of firearms. So I'm assuming that's already happened. If that's the case, then there was probably reliance on the honor system that this individual will do the honorable thing. In fact, what happened here, I think, is that law enforcement gave him the gun back. I think it happened in both of these cases, but this is the point that I'm trying to make with asking these 4 questions. These are 4 questions we should all be asking. If you don't know the answer to all 4 of these, your jurisdiction relies on the honor system. So next slide, please.
And Dave, if I can, before you jump to that next slide, or Rachel does, I just want to say with the 4 questions that Dave just presented really speak to, I think it was the slide, Rachel, that you shared, where you were talking about if you're going to be seeking relief through a protection order and firearm surrender, what does your protocol or your procedure need to look like? And those 4 questions does exactly that. Who has access? Do they have the guns? Ordering surrender, and then that final question is really addressing the compliance piece. So ensuring that the firearms have actually been returned.
Great. So now we're going to quickly touch on some gaps in state law, laws, and some of these apply at the federal level as well. But we're looking at just these 4 things specifically. There are probably others, but these are the four that I have found come up the most in my work in state advocacy. And the first is closing this dating partner loophole, sometimes referred to as the boyfriend loophole, which allows abusive dating partners under certain state laws to keep their firearms, even if they would be prohibited because of abuse. And so we want to make sure that those prohibited from purchasing and possessing firearms are not just someone that you had been married to or have a child in common with, but really anyone who you've been in an intimate relationship with, because we know that nowadays people are not only marrying later, they may be putting off marriage entirely. People are dating, I think, a lot more than they used to for longer periods of time. And so we just want to make sure that these are protections offered to everyone. And I think, I don't know if Rachel's going to talk about this too, but this is a big problem with the Violence Against Women Act too. There is a provision to close this loophole at the federal level as well. Second, we want to make sure that temporary protective orders are firearm prohibitory, not just permanent protective orders. This temporary period is often seen as the period of highest risk because it's when an order is initiated and may set off a trigger to an abuser. I don't like to use that word, but may set off an alarm for an abuser that maybe their guns are going to be taken away. And if they're not taken away under a temporary order, there's still time for them to do harm with that gun. Third, we want to make sure that the relinquishment process for removing firearms is clearly outlined. I mentioned the California law that is seeking to make this a little bit clearer, but there's always room for improvement. Where the firearms have to go, it's not just enough to say that they have to be taken out of the home. When, how often after someone becomes prohibited, and where do they go? Do the firearms go to the police? Do they have a temporary place to keep them? Is it enough to just say that a prohibited person can transfer them to someone that they know? That's obviously risky. And fourth, making all violent misdemeanors firearm prohibitory is an evidence-based practice. This would mean that someone who not only has a history of domestic abuse, but someone who has a history of any violent misdemeanor, whether or not it's directed at an intimate partner, and making sure that those individuals with histories of violence, again, not necessarily just directed towards an intimate partner, are prohibited from purchasing and possessing firearms, because we know that past violence is the best predictor of future violence, and we want to make sure that all forms of past violence are included. Next slide, please.
So a lot of the gaps in federal law really do mirror the gaps in the state laws that Lisa was talking about. So I'll run through these pretty quickly. Federal law doesn't prohibit adjudicated dating partners from possessing firearms. And it doesn't restrict stalking misdemeanors from firearm access. And this includes in intimate partner relationships, right? So in order to trigger the federal firearms law, including, in addition to having those relationship requirements and due process requirements and things like that, it either has to have an element of force or a threat with a deadly weapon. So if it's stalking but doesn't have either of those two elements, it doesn't protect intimate partners. It doesn't protect petitioners for ex parte protective orders, as Lisa said. And then, although the Department of Justice actually issued regulations establishing that convictions under local laws trigger the misdemeanor crime of domestic violence prohibitor, 2 district courts have actually issued rules to the contrary. We think those are ridiculous, but there are 2 areas of the country that have basically different laws about who can carry a firearm, possess a firearm when there's a domestic violence misdemeanor conviction. And then one other gap is that the federal government, they give all sorts of grants to states and localities for enforcement, whether that be enforcement for drug crimes or enforcement for, carjacking. And they also obviously provide grants for gender-based violence to combat gender-based violence. But the federal government doesn't explicitly allow grantees, including grantees under VAWA, doesn't allow them to use their grants to develop and implement policies and protocols to disarm adjudicated abusers, similar to those that we have been talking about. Next slide, please. So there are a number of pending bills that I've been working on personally with my colleagues in the kind of domestic violence and sexual assault policy world that address federal firearms laws pertaining to gender-based violence. And I'm not going to list them all for you. There are very many, and we do have a limited amount of time. But many of them actually have been pulled into one bill, which is the Violence Against Women Reauthorization Act of 2021. So the bipartisan House bill that would reauthorize VAWA, it's HR 1620, it passed the House in mid-March, and it did contain provisions addressing all these gaps that I just mentioned. It closes the dating partner loophole, the stalking loophole, the ex parte loophole, and the loophole related to that are under local law, or in this case, it's municipal law. And it also allows VAWA grantees to use STOP and ICJR grants to develop and implement relinquishment policies and protocols. So we are currently in the process of negotiating a Senate companion bill to HR 1620. As you might imagine, a bipartisan Senate bill is not going to include all of the firearms related provisions that the House bill did. But we are hopeful that we will ultimately settle upon a bipartisan bill that will garner a minimum of 60 votes to clear the filibuster that does address abusers' access to firearms in a meaningful way. Negotiations are ongoing. We've also been working on another bill that hasn't been introduced yet. This is a brand new thing. And it's a victim-centered corollary to some bills that have been kicking around Congress for a while. So the existing bills, they require the background check system to notify state and local law enforcement and prosecutors when someone fails a background check. And actually this provision is included in the House VAWA bill, but it only applies to domestic violence in that case. So these bills haven't actually passed, but it's already happening because the appropriators told the Department of Justice to do it, and because the appropriators put it in their bill, it's law for the year covered by the appropriations bill, basically. It is, and I would argue more, important that survivors know when a prohibited abuser tries to buy a gun, because it might be a sign of escalation. So stay tuned as we're continuing to work on this bill. And it would also include notifications of a change in status. So as Dave was mentioning when he was talking about the federal firearms prohibitors, they're not actually lifetime bans. If somebody has their record expunged, set aside, they're pardoned, or they have their civil rights restored, unless it specifically says that they can't have firearms, then they do, get their firearms rights back. So also that, survivors need to know if there is a change in status, and the abuser can once again access firearms. So stay tuned. And I do just want to mention that we do rely on your advocacy to advance our public policy work. Right now at NCADV, we are focused on getting the VOCA bill passed. By the way, it's not too late to call Senator Schumer's office and tell him to take it to the floor if you haven't done that already. But pretty soon we will be asking for your help in getting a bipartisan VAWA across the finish line. So keep your eyes open for action alerts when we do get to the point where we have a bill to push. Next slide, please. So we've talked a little bit about some of the work that we have done collaboratively, Disarm Domestic Violence, which is a collaboration between NCADV and Lisa's organization and a couple of other organizations. And then Alicia and Dave are here from the National Resource Center on Domestic Violence and Firearms. So we just wanted to give you a super duper brief overview of these two resources, for your future reference and use. Next slide, please. So very quickly about disarm domestic violence. Disarm domestic violence, we call it Disarm DV very affectionately. It is an interactive website that compares the laws for different states. It has stats about gun violence, and it also has information for survivors and for advocates about what the law means for them when they're seeking a protective order, what are their options under the law, what should they be asking for, etc. So it is designed for survivors, for advocates, law enforcement, judges, researchers. I use it a lot, actually. So for example, we were working on VAWA in the House, and it was like the day of the vote, and somebody was like, oh gosh, I need to know how the provisions in VAWA compare to my state law because I don't want to get in trouble with my constituents. So we were able to just like pull up Disarm Domestic Violence and be like, okay, your state has an ex parte prohibitor, so you can vote for this without making your constituents mad. So I've been using it a lot for that as well. It's a great resource. Lisa, next slide, please.
Great, I'll be very quick too, because I want to get to some Q&A. But this is just an image of the homepage on the left, and then an example of kind of what it looks like when you click on a specific state. And so you can click and see, you know, all the prohibitions and the protections offered on the left-hand side. And if you click on the state, we've chosen Texas as an example, you can see again, the shaded regions are the protections that are offered. If you click that little box at the bottom that says compare, you can compare multiple states. You can also see all of the statistics, if they are available, on domestic violence or intimate partner violence homicides in each state, and by firearm, if they have that information available, as well as information on the research surrounding the intersection of domestic violence and firearms at the top of the website. So that is just a visual of what the homepage looks like and what it looks like when you click on one of the states. Next slide, please.
All right, the National Resource Center on Domestic Violence and Firearms. We are a project of BWJP, the Battered Women's Justice Project, and our work really focuses around the intersection, of course, of domestic violence and firearms. Our primary focus since our inception in 2017 has really been on the development of firearm surrender protocols for jurisdictions. So we provide training and consultations, we have online resources, and we do offer peer-to-peer support. All as a comprehensive training and technical assistance provider funded by the DOJ on the Office on Violence Against Women. All of our services are free. We will come to wherever you are and work with you and your team. And we look forward to hearing from you. So please do check out preventdvgunviolence.org. And then with that, I'm going to move us into the next slide. And so hopefully we can get to some questions.
So at the beginning, Dave mentioned that we were just doing a really broad overview today because there are so many different topics kind of falling under the umbrella of the intersection between domestic violence and firearms. So this webinar today was really designed to be the first in a series of webinars. And then, you know, future webinars would really look in more depth at some of these different issues that we've raised today. But we do want to make sure that what we do in the future and include in our series is useful to you. So we do have a poll that we would really appreciate it if y'all would fill out so that we can just determine kind of the future direction to make sure that we are meeting your needs in the future webinar series. So the poll just popped up. Choose as many as you would like. And we really appreciate your input. Maybe we'll wait another 3 minutes so folks can have some time to fill this out and then move on to our next slide.
Okay, it looks like we've reached, most folks have responded. So I'll end the polling and I'll share the results. So I guess the answer is all, but it looks like the most popular are hovering around firearm surrender and removal of policy and practice. Excellent. We can make that happen. DV protection orders and extreme risk protection orders, full faith and credit for protection orders at DV and firearm suicide are looking like they're at the top of the list. So we'll certainly, I'll circle back together and see what else we can put into place.
Y'all are going to be hearing a lot from us in that case.
That's okay. It's a good topic. All right. So I certainly don't want to take over. If you all have other slides or other points you wish to present, let me know. Otherwise, we can open it up to questions.
Do you want to take it to the next slide where it has our contact information?
Yeah. Oops, sorry. I'm seeing two different things here. Pardon me. All right. Yes.
While we're waiting, if I could just briefly respond to the question that was asked before the webinar started.
Please do. That'd be wonderful.
This is a great question. It has to do with, as I mentioned before, an individual from what I understand, one in Alabama and one in Mississippi. And it sounds to me like firearms were returned to these individuals, and these individuals should not have had firearms. There's really a lot going on here. The narrow question that was asked is, how often does this happen? And that's another excellent point. I don't know if anybody else here has the answer. To my knowledge, there is no statistic, there's no database that shows individuals who had guns returned and then committed homicides, domestic homicides with those. So the short answer is I don't think that's known. But it highlights a very important issue that was raised both by Lisa and by Rachel, which is that we need to have more research done and more statistics done on these kinds of things. For me, what's important though is really the practice of returning a firearm, giving a firearm to somebody who probably without any argument should not have had the firearm. The short answer to your question about statistics is if it happens to one person, if one person is murdered by their intimate partner with a gun, then it's too many. So this is something that I think we can't emphasize enough. There's all the indications that this could be homicidal if you give this person the gun and it happens anyway, and we can't bring that victim of the homicide back. So thank you for that question, and I would be happy to talk to you at length about it if you've got follow-up questions on that.
And I want to add something really quickly to what Dave said, because actually it was something that I was having a conversation with somebody else about, who brought up a case in which an individual was arrested, let out on bail, and law enforcement returned their firearm. In that case, there had not been a conviction. There was not a protective order. And so legally under current law, or at least under federal law, they weren't prohibited from having a firearm. There was no conviction, there was no adjudication yet. And so they law enforcement returned the firearm, and the individual shot and killed his girlfriend. Also, I did want to mention in the case that you brought up in Mississippi and Alabama, it was not only illegal for the individual to have a firearm, but the person who transferred the firearm back to them also committed a federal felony. So I do just want to, not to put too fine a point on it, but that was also illegal under federal firearms code.
Excellent.
Thank you. That was somebody, I believe the person who asked that original question was just following up with that piece of it, was is law enforcement in violation themselves of federal law if they're returning the firearm in that case? So thank you for that.
Yes, if the individual is prohibited, then there will, yes.
Yeah, and I completely agree with what Rachel stated here. One thing that we urge communities to do is something that can be done in this case, and it should be at least considered, is setting as a condition of bond that firearms be surrendered and that no firearms be possessed. It's done routinely, for example, in violent cases where there's, for example, a battery charge or a disorderly conduct charge, that the court will order as a condition of release, no consumption of alcohol. There are many communities who at the same time in a domestic situation order no possession of firearms. There are even some jurisdictions where they order relinquishment of firearms as a condition of bond.
Sometimes also, and I don't know how frequently this is, but they will issue a protective order coinciding with the release of the individual pending a trial. So.
And those may implicate the federal prohibition on firearms as well. So it's something to consider, you know, when you're talking policy about these kinds of things.
And then I know we're like going back and forth, but also it's not just civil protective orders that that trigger the federal firearms prohibitor. If it is a criminal protective order and it includes, you know, it has the same relationship and the same findings and elements that are required under federal law, a criminal protective order would also trigger the federal firearms prohibitor. That was probably more than I actually wanted to know, but.
That's okay. We also have a question here that says, can a victim of domestic violence file both a DV, PO, and an ER?
I think Dave touched on that a little bit.
Go ahead.
Go ahead. It's not recommended. Dave, you go ahead because you stated it earlier.
They're not inconsistent with each other. So I think certainly the answer is yes. You could, that person could file both. There's lots of situations where those facts will be relevant to both types of protection order. But I don't think it's really, in most cases, it shouldn't be necessary. And the concern that we have is that if you do both, you're going to start to confuse the courts. The court's going to start to conflate the two standards. So I don't think it's recommended. Rachel mentioned that there are situations where a DV survivor might file only for extreme risk protection order, only for the firearms. That certainly is conceivable that could happen. It's probably not going to be very common, but you could do that. I mean, it is possible.
And I would just also add one more thing. You know, first of all, I think we talked about full faith credit. We talked about that there's other relief necessary, but you know, I would add two things. First of all, the standard, well, the kind of evidence that you would present would often be different, but also sometimes the standard of proof is different. We really strongly discourage that, and folks have been hearing it from us a lot, but in most, but not all states, the standard of proof for a domestic violence protective order is preponderance of evidence. In some states, the evidentiary standard for an extreme risk order is clear and convincing evidence. So it is also a higher bar, which is something else to consider. And for folks who are considering working on legislation related to extreme risk orders, we would very, very strongly recommend against having a higher threshold for an ERPO.
Great. Okay. I don't see other questions coming in, but we'll give it another minute or two and encourage people to please post any questions or comments you may have in the chat box or in the question and answer box. Here's one. It says, if local law enforcement in court refuse to enforce the plain language of the order of protection requiring surrender of firearms to a law enforcement agency, so the next step would be contacting the feds, ATF, I believe. Any suggestions for how to go about using this route, especially considering police and court do not share our view on this issue?
So I actually have a great response to that, going back to VAWA, actually. There are a number different provisions in VAWA related to firearms. As I mentioned, I talked about the prohibitors, but one of the other things that we're really looking at is enforcement, and how do we make sure that the laws on the book are as effective as they can be. So one of the other provisions that we haven't talked about is to cross-deputize state and local law enforcement as ATF agents and prosecutors as, oh wait, no, that's the other one. That is true, but in this case, what I really meant was that that it would require all of the district offices of the U.S. attorneys and the field offices of the ATF to establish points of contact for domestic violence, and for those points of contact to have a relationship with not only local law enforcement, but also the local programs and the state and tribal coalitions. So that if there is a situation in which the either the local law enforcement just doesn't want, for whatever reason, isn't enforcing, or they don't believe it's important enough to bring in a federal response, that there is already that line of communication between the local program, so that they can call up the ATF and U.S. Attorney's Office and say, hey, we need you, this is a really serious case, here are all the things that are going on, we need you to intervene. So that, I think, is probably something that will make it into a final version. It is not something that is super controversial anyway. They're already doing it in a lot of jurisdictions. So.
Great. Okay. I see no other questions coming in. We'll give folks just a few seconds to post anything in the event anyone has anything to ask. In the meantime, presenters, I don't know if you have any final thoughts or other information you want to share. We have a couple minutes left before the top or the bottom of the hour. So
I would just say thank you for taking part in that poll. I think that's really, we were hoping to find out what you want to hear from us, and we'll start to plan on putting things together for you.
I would echo that and just say that all three of our organizations have a shared mission and goal in preventing domestic violence with a gun, but we all have such different and great resources on our website. So please check them out, whether you're interested in full faith and credit or domestic violence provisions or gun violence prevention in general. I think that we should hopefully have everything you need. If not, please email any of us. Our emails are on the slide now and we're happy to help.
absolutely. Thank you so much. And again, as we mentioned at the beginning of this session, we will be sending all contact information, a recording of this webinar, as well as a copy of the PowerPoint, and then a link to a downloadable certificate of attendance within a few days. So it takes us a day or two to get the recording all calibrated and whatnot. So thank you everyone for